Hi students, welcome to lesson number 13 on the types and settlement of industrial disputes. The introduction. In terms of labor law, strikes and lockouts refer to the acts taken by employees and employers respectively to satisfy their demands. The lockout is a solution for the employer of the company or industry, whereas the strike is a remedy for the employees. Lockouts and strikes are tools in the battle between employers and labor. The production of the industry is impacted by strikes, whereas employees' salaries are impacted by lockouts. Law permits strikes and lockouts to take place in the workplace. However, both must be amicable and adhere to the requirements of the Industrial Dispute Act of 1947. And the main mechanisms for resolving industrial disputes are voluntary arbitration, adjudication, conciliation and negotiation. This equipment has been made available under the 1947 Industrial Dispute Act in actuality. It offers a legalistic framework for solving or resolving the conflicts. As was previously said, the aim of preventive machinery is to create a situation in which disputes never ever occur. Even then, if there are any disagreements, the judicial system has been set up to resolve them to prevent work stoppages. In this regard, the machinery's nature is therapeutic because it attempts to treat illness. And the objectives for the lessons are that this lesson will help the student to understand the various forms of industrial dispute and also the various methods of settlement of industrial dispute. Now, let us understand what is a strike, what is a lockout, what are layoff and what are retrenchment. Now, let us understand what is strike. According to the definition of strike by section 2Q of the Industrial Dispute Act 1947, strike is a temporary cessation of the work by the group of the employees of the industry with the same intention to stop the work. The strike means a refusal of work that is decided by the association of a group of employees or workers. It is done by the workers to get their necessary demands fulfilled by the employer of the company or industry. The strike includes willful suspension of work. It is a temporary withdrawal of the workers from the work. The workers can do the strike outside or inside of the workplace. The common understanding for the suspension of the work should be present for the strike. It can be continued for any number of days and the workers start working when the demands are fulfilled. The strike can make a loss to the industry as the workers will not do any kind of work. The production or growth of the industry can take the loss. And the essentials of the strikes are: first one, cessation of work; second, cessation of work in combination by a group of employed persons in the industry; third, the persons should be employed in the industry; fourth, the refusal of work must be the refusal of common understanding by such persons. Cessation of the work in the industry is an essential element for the strikes. Cessation of work means the work of the industry has been stopped. Even the period for the stoppage is only their half hour, still it will fail in the definition of a strike if the other requirements of the definitions are fulfilled. Cessation of work in combination by a group of employed persons in the industry means the stoppage of work must be with the common intention of the employees and that too in defiance of the authority of employers. Now, what is a lockout? According to the section 2(1) of the Industrial Dispute Act 1947, it defines lockout as temporary closing of the industry or the suspension of work or the refusal of the work by the employer of the industry to continue employment to any number of workmen employed within the industry. Features of the lockout include: first one, closure of industrial undertaking when employer apprehends a destruction or damage to his property in the event of industrial dispute. Second, as long as employer refuses to give work, there is suspension of employer-employee relationship. Third, it is a weapon in hands of the employer to force them to give in to his demands. It is an antithesis of strike. Coercion and retaliation are the main elements of the lockout that must be used by the employer. The mere suspension of the work without accompanied by an intention to retaliate will not amount to lockout. If the employer of the industry shut down the work because the raw material or the fuel or any necessary material is not present, it will not amount to lockout. The common reasons for lockout here is that the first one, in response to a strike initiated by employees. Second, disputes between workers and managers. Third, changes in the government rules. Fourth, illegal activity is undertaken in the company. Now, what is a layoff? The layoff may be defined as a provisional separation of the employees at the will of the employer because of his or her inability to give employment to the employee whose name is entered on the muster rolls of the establishment and is not retrenched. It can be caused due to a shortage of resources such as coal, power or raw material, economic slowdown, machinery breakdown, accumulation of stock and so on. Layoff lasts for a particular period which ends up. The employee will be recalled by the employer to join the office or factory at the same job and position. However, the period may extend to any length of time. The employee provided with adequate compensation by the employer because layoff takes place at the instance of the employer. The essential conditions where layoff could be brought into play are: there has to be a failure, refusal or inability of an employer. Second, this failure, refusal or inability should be an offshoot of the shortage of coal, power or raw materials or the accumulation of stocks or the breakdown of machinery or natural calamity or for any other unconnected reason. Third, the names of the laid off workers should necessarily feature on the muster rolls of the establishment. The said workers should not have been retrenched. Now, what is retrenchment? Retrenchment as a termination by the employer of the services of a workman for any reason whatsoever otherwise than as a punishment inflicted by way of disciplinary action, but does not include: first one, voluntary retirement of the workman or retirement of the workman on reaching the age of superannuation if the contract of employment between the employer and the workman concerned contains a stipulation in that behalf; the termination of the services of the workman as a result of the non-renewal of the contract of employment between the employer and the workman concerned on its expiry or of such contract being terminated under a stipulation in that behalf contained therein; termination of the service of a workman on the ground of continued ill health. Here, the key ingredient is the termination of a workman from service by the employer. This does not mean the employer can retrench a worker as a punishment by way of disciplinary action. Further, this scenario strictly does not include the above mentioned conditions contemplated under the subsections, that is the special provisions. It is pertinent to note that a worker who has served for at least a year of continuous service cannot be retrenched unless served a notice 3 months in advance and prior permission from the appropriate government. The said application has to be submitted by the employer along with the reason for such retrenchment. The said application will be taken into consideration and scrutinized through an inquiry. They shall provide an opportunity to be heard for both sides and may decide on the outcome of the application for reasons recorded in writing. If there is no reply from the appropriate government for a period of 60 days from the date of application, the permission shall be deemed to have been granted. Further, it is to be noted that the said decision could be reviewed by the said appropriate government suo motu or an application from any of the sides. Now, let us look into or probe into what are the various methods of settlement of industrial disputes. Industrial conflicts can be resolved in a number of ways, including through negotiation, conciliation, mediation and arbitration. Any organization, management or trade union has the freedom and right to use any means to settle labor issues. What is crucial in this situation is that industrial conflicts must be resolved as soon as they arise and at the appropriate level. Both the management and the union should adopt a different mindset, put their egos aside and work to settle the conflict as quickly as possible. Relations progressively deteriorate and become complicated when disagreements are not resolved. There should be a win-win situation. If both management and unions are to be happy, if one wins and one loses, relations do not and can never improve. Pending awards can lead to less productivity and losses for both employer and employees. Both the parties as far as possible should resort to negotiation instead of tribunals or conciliation. Now, let us look at negotiation. For resolving industrial dispute, one of the best method is negotiation. It is in negotiation the two parties, that is the employer or management and workers or the unions, depend upon themselves for the settlement of disputes. Both the parties have faith and confidence in each other and do not feel the need of a third party. This method of resolving disputes gives importance to dialogue or bipartite dialogue without the government intervention. This method of resolving disputes shows a higher level of maturity in the relationship between management and unions. This is possible when both the parties are well organized, having faith in each other, ready to reorganize each other, ready to recognize each other's position and dignity. Things become more easy for negotiation when both the parties are ready to adjust and accommodate each other's point of view. Through conversation supported by moral sanctions, both parties come to a wider or written agreement to address their differences. The written agreement between management and the workers' union is more widely accepted by all parties. Conflicts are settled and relations are maintained at the same time. If the negotiating process machinery malfunctions, the issues between the parties remain unresolved. In such circumstances, both sides reach at a point of impasse, at which moment direct disagreement between the two parties starts. Unquestionably leading to conflict and discord, such conflict and discord causes loss of time, money and energy, leads to poor employees' relations, damages the organization and raises issues of larger concern for society and the government. The other method is the conciliation method, and in this method of resolving disputes, both the employer and the employee union take the help from outside, such as the government agency. The government agency tries to bring the two parties, the management and unions together for discussion and help them in their negotiation. And the main objective of conciliation is to reunite the two conflictive groups in the industry to avoid further problems of production, disinterest and strain industrial relations. This method of resolving industrial disputes is adopted when the parties cannot reconcile their differences on their own and still want to avoid the problems of open conflict. Conciliation is a practice by which the services of a neutral third party are used in the dispute to make the disputing parties come to an amicable settlement. Conciliation process takes under the guidance of a conciliator. Conciliation machinery consists of a conciliation officer and a board of conciliation. So, under section 12(2) of the Industrial Dispute Act of 1947, the conciliation officer shall be involved for the purpose of bringing about a settlement of the dispute. The conciliation officer plays the role of an innovator, protector, discussion guide, leader, advisor and communication link between the two parties. If the conciliation does not get results in the course of conciliation proceedings, then the conciliation officer sends a report to the appropriate government, a failure report informing that a settlement cannot be arrived at. To make conciliation more effective, the National Commission on Labour has recommended that conciliation machinery should be a part of the Industrial Relations Commission, which will make it free from other influences. The independent character of the machinery will alone develop greater confidence and will be able to evoke more cooperation from the parties. Another method of settlement of dispute is mediation. Mediation often becomes a crucial tool when the two parties to a disagreement are unable to reach an agreement during negotiation or when the best course of action cannot be determined. Industrial disputes can be resolved through mediation with the aid of an impartial third party. The mediator takes a very constructive approach and plays a constructive role by gathering information from both the management and the union, properly evaluating their perspectives and interest and then making recommendations for reaching a resolution or for reaching a fair compromise in the light of information. An outsider plays a part in both mediation and conciliation, and in both situations the success of the process heavily rests on the parties' ability to communicate. A lot hinges on changes for shared advantage in both case conciliation and mediation. Conciliation and mediation are consultative processes, not adjudicative ones. The mediator serves as a facilitator, revealing to the disputing parties fresh points of agreement that they would not have found on their own. Now, another method is arbitration. The word arbitration means settlement of industrial disputes between two or more parties by means of a decision of an impartial body when efforts in the process of conciliation and mediation have failed. Arbitration is judicial in nature, whereas conciliation is advisory in nature. Arbitration is voluntary if the parties to the dispute have failed to settle their differences by negotiation and conciliation, agree to submit them to arbitration as prescribed under the section IOA of the Industrial Dispute Act 1947. Compulsory arbitration or adjudication, the government requires the parties to the dispute to submit their differences to an arbitration tribunal which, after considering the facts and arguments submitted to it, makes an award. So, in case of voluntary arbitration, it does not necessarily follow the procedure accepted by the courts. So, the fundamentals of voluntary arbitration are that the dispute must be voluntarily submitted to an arbitrator and there should be no compulsion. As a result, the execution of an award may not be necessary or binding. So, when the parties are unable to reach a settlement through the voluntary alternatives, mandatory arbitration is adopted. So, arbitration that is mandatory may be required and preferable in some situation. The goal of government action in labor relations should be to uphold social fairness and strengthen the weaker party so that it can resolve disputes through negotiation and collective bargaining. When the parties to a dispute cannot settle it through voluntary means, when there is a national emergency, when the nation is experiencing economic hardship, when the parties to the disputes are not fairly balanced, when the unions are weak and unorganized, when the employers are well organized and more powerful, or when industries of strategic importance are involved, the parties are forced to arbitrate by the state. To summarize, industrial relations in general relate to the interaction that develops between labor and management during normal working hours. The field of industrial relation has expanded as a result of the development of professional management as well as improvements in productions and information technology. The government, employers, associations and unions are the three main players in industrial relations. So, prior to the declaration of an emergency, strikes dominated industrial disputes in India up until 1975. Employers became more militant during the emergency of 1975-76 and the number of May days lost because of lockouts sharply increased. Since 1980 and especially following the lockouts of 1984-1985, the working classes has been subjected to progressively harsher sanctions. In the private sector, there are several disputes and they are compared to the private sector. Disagreements are more intense in terms of May days missed and the average number of days a worker is involved. So, industrial disputes have two parts, prevention and resolution. At the national level, there are facilities for tripartite consultations and at the corporate and shop floor level, there are provisions for joint management councils and works committee. So, for the settlement of industrial disputes, Industrial Dispute Act 1947 provides settlement machinery comprising of conciliation officer, board of conciliation, court of inquiry, labor courts and industrial tribunals, National Arbitration Promotion Board, code of disciplines, industrial truce or other voluntary measures for settling the disputes.